Hey everyone, Rob Ryder. It's Thursday, February 21st, 2013. I spent a little time talking about this book, Land Registration in Illinois. What I had to say. Um, and really, it's based on a few things that we had found while we're working on Roe's case in Illinois. And so, this is a Illinois compiled statute 735 ILCS 5/12-101, which, among other things, says the first class consists of all real property, the title of which is registered under the Act Concerning Titles, approved May 1st, 1987. And has to do with this Section 85 of the Act Concerning Land Titles. Well, kept finding this stuff in different places where we would talk about this Act Concerning Land Titles. This one's about foreign judgments. Until its transcript, certified copy, memorandum of the lien is filed in the office of the recorder in the county in which the real estate is located. Foreign judgment registered pursuant to that section, entered on the foreign judgment, is filed in the office of the recorder. So we got the office of the recorder, we got the Act Concerning Land Titles. This talks about the type of notice they're supposed to give you. This is if you're redeeming your property. And this is what should have been mailed to you if you were in a tax sale to redeem your property. And I talked to Roe, and she didn't get anything that looked anything like this, but sold for general taxes of year whatever. Sold for special assessment of. So they would have to have the special assessment and general taxes down here, and it would have a warrant number. And we found out that someplace there is a warrant book in the county recorder's office. So this had more to do with expiration or of redemption. Another notice that you should have gotten. And these notices aren't coming to people. It has something to do with using different addresses. The amount of redemption shall deposit the amount specified in the section with the county clerk. Property is situated. And part of that was all fees to the register of titles incident to registering the tax certificate in compliance with the Registered Title Torrens Act. Our good friend Torrens, talked about him a year and a half ago. And now we're going to figure out how they're actually using it. And so here's another different statute. Upon the assignment in whole or in part by the holder of any charge upon registered land being presented and accepted by the registrar shall enter in the register a memorial of such transfer. Lots of things happening. Every mortgage or trust deed in the nature of a mortgage shall, as to lands not registered, now lands not registered under the Act, from the time it is filed of record. So if it hasn't been registered, it's filed of record. And in case a land's registered under the provisions, from the time it is registered or from the time of filing a caveat, still got to figure out what the caveat is, as provided in said act, be a lien upon the real estate. So before there can be a lien upon the real estate, it had to be registered or filed of record. That would be your deed of trust or mortgage. But I don't believe those have happened yet, so they really can't be used as a lien. For all monies advanced or applied, which may at any time thereafter be advanced or applied thereunder on account of the principal indebtedness. Anyways, just interesting things. It talks about liens upon real estate, all these different acts, and then it keeps going back to the this act concerning land titles. So you wanted to see, and lien of judgment had the same thing, joint tenancy, land title, all the stuff on land titles. So we started to look into what that was all about, and found this book. And we'll just read some quick pages here. Let's see. So you can get this off archive.org, archive.org. Just put in land registration in Illinois by Theodore Sheldon, who was an examiner of titles for Cook County, so he might know something about the registration of land. And in the table of contents, we see I'm going to talk about land registration a little bit, the procedure and the practice, the Illinois Torrens Law, new and old systems compared, the Torrens system adapted to American constitutions, because there were some constitutional issues. In fact, they spent a lot of pages talking about Supreme Court opinions that came out of trying to implement this system. Registration in other counties and states. So not every place uses the Torrens system, but every place has some kind of land registration. And it's important to understand, and so that's what we're trying to work through right now, is how we can use this to our advantage. But let's just read a little bit. This is the practice and procedures. Okay, so the recorder of deeds is made the register of titles, and in addition to his duties as recorder, conducts the registration of titles and dealings with registered land. He is assisted by deputies and examiners of title that later are attorneys at law. So there was an initial registration. So without getting into a lot of detail, one of the problems they had putting this system in is they wanted to have somebody like the register of titles do the work. But he had to make a judicial determination on the initial registration. So the first time they tried to put it in, it was shot down, saying that was somebody who just has a ministerial office performing a judicial function, and that wouldn't work. So the solution, the second time they did it, well, it was like 1895 and now 1897. They said, okay, well, since it is optional with the owner to register his land, remember that you can unregister your land at any time once you find it. He files in a court of competent jurisdiction his application in writing for registration of the title. This in ordinary cases can be the following form. So he files in a court of competent jurisdiction, and he writes this to the judges of the Circuit Court of Cook County in Chancery sitting. So the very first thing that happened to be able to register land is it had to go to the Court of Chancery first. And the guy made an application, and so this would be the way you would address something in Illinois to get it into the Court of Chancery if you have a bill of complaint about something else or about this. To the judges of the Circuit Court of Cook County in Chancery sitting, you just addressed it to the Circuit Court that's over Cook County in Chancery, and you took it out of the law jurisdiction. So in this case, though, it's a guy who's applying. He's making an application to register his land. And this is just some of the information that was on it. I won't spend too much time looking at that, but that's really what that part is. And, once everybody got the blessing, it could be done. Where are you? So then, in all dealings with land after registration, the bona fide purchaser or encumbrancer has like security to that given to the purchaser of negotiable paper. The title of such purchaser or encumbrancer cannot be upset. So we just need to get the title. Well, how is it transferred? Transfers of registered land are made in the following manner. The owner executes the usual deed, that would be the warranty deed, and submits it together with his certificate of title to the buyer. Did you ever see the owner, the guy you bought it from, his certificate of title? Well, you were supposed to get his deed and the title, because in every transaction the owner must produce his duplicate certificate of title. He can do absolutely nothing without it. If lost or destroyed upon proper showing, the owner receives a certified copy marked owner's certified copy, issued in place of a duplicate lost. This, after entry of the transaction upon the original certificate of title, answers the purpose of the lost certificate. So, if you don't have the owner's certificate of title, then you need to get a certified copy of the owner's title. And so this owner is the grantor of the warranty deed of which you were the grantee of. He's the owner. He had a certified copy. So they're saying, owner's certificate of title. This owner's certificate of title is what you give away when you do a deed of trust, when you transfer the title on the deed of trust to the real property. That's why you didn't get his owner's certificate of title. It went to the bank. So, now here's why that's important. This after the entry becomes, okay. So then, no new forms of conveyances are required. The buyer, after inspection, now this is you, after the inspection of the original certificate of title in the register, because in the register is the original certificate of title, and the owner has a owner's certificate of title. So you would take the owner's certificate of title, go to the register and say, I want to see the original certificate of title for this owner, and show him his copy. That's how it should have worked. And then they would have taken you to look at it, and finding thereon no encumbrances or lien, safely pays over the purchase money and receives the deed and duplicate certificate of title. So you wanted to buy the property. You would go to the register. You want to see the original, because any liens or encumbrances on the land, on the property, have to be indexed or recorded, or whatever the word would be, on this original certificate of title. And if you go there and don't see any liens, there are no liens. And then you would go pay over the money, and you would get the deed and the duplicate certificate of title. Well, we don't have that duplicate. But what we would do then is he then delivers them both to the registrar, who, when satisfied as to the identity of the parties that the transfer should be made, notes the transfer in the register. This operates to transfer the title. No title passes by delivery of the deed. That warranty deed doesn't do a damn thing for you by itself. It does not pass title. The deed, after delivery and before the registration of the transfer, is a mere contract between the parties. It's a purchase agreement. Its sole object is to authorize the registrar to register the transfer. The transfer is registered when the registrar cancels the old certificate of title and issues a new one in duplicate as before. One called the original, that's the one that the registrar is going to keep, and the other called the duplicate, which is the one they're going to give you. After proper receipt thereof, filed with the registrar, delivered to the buyer, now the new owner. The deed is kept by the registrar. This isn't the same office where your deed is now. Somebody put it there really without your permission. It's not where you wanted it recorded. You want it recorded in the office of the registrar. Now, this talked about the recorder of deeds has made the register of titles. Let's see what we had here. This is Coles County, Illinois. The clerk is also ex officio recorder of deeds for Coles County. Okay, and we know that the recorder of deeds is made the register of titles. So, the county clerk, who is the ex officio recorder of deeds, is also then the register of titles. You need to go to the clerk's office and look what the clerk does. Elections, records of deeds, recorder of deeds, vital records, tax services, clerk of the Cole County Board, which is actually a court. So you go to the county clerk. You don't go to the recorder's office. You go to the county clerk, which is the office of the recorder. Confusing, but not really. Just different hats. Alright, so that's how it's transferred. You go to this county clerk now. We're just called the county clerk to make it easy. and you take them your warranty deed and tell them that you want to look at the original certificate of title. Excuse me. Owner certified copy. No new forms. The buyer, after inspection of the original certificate of title in the register. So you want to go look at the original certificate of title in the register and then give them your warranty deed and say, hey, I'm the new owner. Because it's whatever is on this. If the buyer, after inspection on the original certificate of title, it's whatever's indexed on the title are the only liens that exist. And right now in this particular jurisdiction, in the office of the recorder, we're not seen as the owner because we haven't gone there to do this transfer. No title passes by delivery of the deed. The deed after delivery and before registration of the transfer is a mere contract between the parties. We got one more step to go. Mortgages. A mortgage of registered land is affected in somewhat the same manner. The owner executes a mortgage in duplicate and delivers with a note or bond of his and a certificate of title to the lender. Well, we gave him a note, but it's a promissory note, which is actually a security. And we didn't do a mortgage, small lowercase. We did a deed of trust or mortgage as a security instrument. And we gave the certificate of title on that instrument as collateral. The later, after the inspection of the proper portfolio and register and finding there are no encumbrances or liens, safely pays over the money to the borrower. Well, they didn't pay us any money. And receives the mortgage securities with the certificate of title. There's where the bank got it. The note, bond, and duplicate mortgage are presented to the registrar, who identifies the note and bond and notes the transaction upon the register as well as upon the owner's certificate of title. The later, with the note or bond, is thereupon returned to the borrower. The later, the note or bond is thereupon returned to the borrower, who may use the same in effecting a second or third mortgage. So they were still supposed to return you the owner's certificate of title. One of the duplicate mortgages is retained by the registrar. The other, with the date of the registration endorsed thereon by the registrar, and the note, the bond, is delivered to the lender. When the mortgage is paid, a release of the same is filed with the registrar, who, when satisfied that the note and bond is duly paid, thereby notes the release upon the register book, as well as duplicate certificate of title. The later is then returned to the owner, and he may surrender it to the registrar for cancellation and receive new duplicate certificate of title containing no mention of the mortgage. All that being said, right now, who knows, maybe there's something on that owner's certificate of title says there's a mortgage. There's only one way to find out. You need to go look at the original certificate of title for the land description, not for you, for the land description. So what we're trying to do is figure out what the correct address is to call it the land. And we'll see how they do that here shortly. Trust. Registered owners by deed or other instrument filed with the registrar may create such trust as be desired. The terms of the trust are not set forth in the certificate of title, but after the name of the trustee is inserted, the word "in trust" upon consideration or with limitation, as the case may be, and no subsequent transfer or dealing can be had thereafter, except upon the order of the court of proper jurisdiction or upon the written opinion of at least two of the examiners of the title that the proposed transfer or dealing in accordance with the terms of the trust, conditions, or limitations. So I think with the original instrument, when this was first done, it was put into trust. And since we're never actually ever seeing these owner's certificates of title, we don't know what they say because we haven't gone to look at the original entry. But once you find where the owner's certificate of title is recorded or whatever in this office, everything is indexed off of there and you can find the original books. No judgment, decree, attachment, lis pendens, mechanics lien, or other statutory, legal, or equitable lien, except taxes and special assessments, for which a sale has not yet been had, is a lien upon registered land until a certified copy of the judicial proceeding or copy of the instrument upon which the lien is based is filed with the registrar, and a brief note thereof is entered by him upon the certificate of title in the register. So again, if you look at the certificate of title and register, it would say there's a lien and where it was recorded. You would go to that other file and find the lien. If that hasn't happened, there is no judgment, decree, attachment, or lis pendens, or mechanics lien, or other statutory equitable liens unless they've done that, except for taxes and special assessments. And we're not talking your property taxes like you think of. We're talking the library tax, the street light tax, the $2 tax. Provision is made for all who wish to give notice of a lien upon claim against registered land. All such notices are entered by the register upon the proper certificate of title in the register's book. Again, has to be on the register's book, on the proper certificate title, and thus brought directly to the attention of anyone opposing to deal or proposing to deal with the registered land, until such claims are removed as they may be proper proceedings provided in the Act. The register will enter them upon all succeeding certificates of title. So here's the interesting thing. Let's say there was a lien put on when this first went in, and because nobody's ever seen these documents, they don't know that that lien still exists. But once a lien, always a lien until it's removed. They just keep putting on certificates, succeeding certificates of title. And Bobby in Arizona found indication of this in Arizona, that's what they're doing. I can't remember the exact details of it, but some minuscule little thing that looks like it may not have been taken care of on the first registration, and it just carries through. Can't be removed until it's paid. Notice is thus given to mechanics, liens, foreclosures, attachments, other suits affecting land, unregistered mortgage, or other legal equitable trust, liens of any kind, sale for taxes, special assessment. Anyways, all these things, for them to have anything to do with your land, have to be in the on the owner's certificate of title, recorded in the registrar's office, which the way they call it, the original certificate of title. You got the owner's copy. The only difference is you got your copy at home and the other one is kept in the office, and anytime somebody puts a lien against your property, it goes on there. And then you're supposed to be noticed, probably by the address that's on that owner's certificate of title. But what if it doesn't show you yet? What if it still shows the grantor that you bought it from, because his copy that you should have gotten to do this went to the bank? And you haven't gone here to take care of this yet, so I'm sure that the bank hasn't. There's a very good chance that the last owner showing on the property is the guy before you. They're always keeping us one step behind, just like taxes. If you pay 2011's taxes that were due in 2011 at the end of 2012, well, they're almost a year overdue. What they do is in 2011, if you haven't paid them by the end of 2011, they put a lien against your property. And then you go into the redemption period, and you have 1 year redemption. If you don't redeem in 1 year, then they can have a tax sale. So, come the end of October of the following year, if you go pay your taxes, well, that's fine. You paid 2011's taxes. You didn't pay 2012's, which will be due in just a couple more days, or 40 days or whatever. But you took care of 2011. They'll just put a lien on you again at the end of 2012. If you pay by the end of 2013, that lien will be lifted. They'll wait, put another lien on you. You got to pay your taxes in the year they're due. But you don't go to the treasurer to pay your property taxes. You go to the tax window in the clerk's office, and you pay the general taxes, because they collect the taxes for the county, all the taxing districts. They're the trustee for all the taxing districts. And this one's really good too. Transmission. Upon the death of a registered owner for the purpose of distribution of his estate, his registered lands are treated as personal property. Well, how can you treat registered land as personal property? Right, you don't get to take the land with you. So his registered land is really just paper, and it's treated as personal property. It's just the deed. And because they're personal property, they pass not to the heirs or devisee, but to the executor or the administrator. Because they say, well, we're just going to say they're personal property, and apparently that doesn't. Only real property goes to the heirs or devisees, and the rest goes to the executors or the administrators. Before transferring or otherwise dealing with the land, the executor or administrator must file with the registrar, as authority for such transfer or dealing, a certified copy of an order of the court administering upon the estate of the deceased owner. So the executor must file with the registrar, as authority for such transfer or dealing, a certified copy of an order of the court administering upon the estate of the deceased owner. Sounds like the probate court. In the case of the ordinary distribution among devisees or heirs, the executor administrator, upon proper authority from the court appointing him, will apply to the registrar to have the land transferred to the devisee or heir. The sale of land for the payment of debts will be conducted as heretofore. On filing with the registrar's office the deed and order of confirmation of sale, directing him to do so, the registrar will transfer the lands to the purchaser at such sale. The great advantage of this change in administering upon land a deceased owner are manifest. All questions concerning heirship, dower, rights, creditors are thus conclusively settled at the time and do not continue, as under old systems, and remain for years afterwards as possible, defects in the title. Yeah, that's a great advantage. So, if your ancestor's a decedent, you need to go get a piece of paper from the probate court making you the executor, take it to the registrar to have the land transferred to the heir. But again, they said the land's going to be treated as personal property. Personal property is, it can be real like a car, but it's not really real personal property. More like negotiable instruments. Because the land's going to stay there for the next person to use. His registered lands are treated as personal property, and as such do not pass not to the heirs but to the executors and administrators. Before transferring or otherwise dealing with the land, the executor or administrator must file with the registrar as authority for such transfer or dealing a certified copy of an order of the court administering upon the estate of the deceased owner. Well, again, it just sounds like probate court. You get an order from probate and you take it here, and you can release the personal property of the decedent to the heirs. Tax sales. Holder of a tax certificate of sale must within 3 months after date of sale file a certificate of sale or a sworn copy thereof to the registrar for entry upon the proper certificate of title, and during the same period must mail to all persons noted upon the certificate of title as interest in land a notice of the registration of the tax certificate of sale. Now that's supposed to come from the buyer. Roe didn't get any of that kind of stuff. I don't think any of us get it from the buyer. It's because got the wrong address. Proceedings in Chancery. This act provides ready recourse to court of equity in all cases of wrong, doubt, or mistake, and the courts have all times full control over the registrar. The Court of Chancery has full control over the registrar. The title of a bona fide purchaser or encumbrancer will always be upheld. Well, the bank didn't purchase it from us because they didn't sign the contract, so it's not a bona fide purchaser. We bought it from the grantor, we have a warranty deed that says he was paid in full and he's happy with the deal. We're the bona fide purchaser. The Court of Chancery will always uphold your title. So, indemnity fund, okay, that was enough on that. Page mine, 29, 34. Recorders, ex officio registrars, okay? So it is enacted by the people of Illinois, represented by General Assembly. Recorders and ex officio recorders of deeds in the several counties of the state shall be registrars of titles in their respective counties. Don't let them tell you different. And then a few more good pages to read. It's all pretty good to read, but it's just too much to put on a video, so I send the book along. Okay, when a lien to affect title of registered land, no statutory lien shall be deemed to affect the title of registered land until memorial thereof is entered upon the registrar as herein provided. This extends to all liens the requirement of notation upon the proper certificate of title before validity as lien upon the registered land. The area search for all liens is thus reduced to a single page in the Register of Titles. Find your register of title for your land. It's not under your name. It's the land that's registered. It has a file. Now, it could be that the address of it, it sounds like what Bobby told me, it's the lot is the address. Look at your legal description where it starts with lot. That part is actually the address of the property. And you have a mailing address. Right? So they go to send it to the owner of the property. They use the lot address, and of course you're not there. So your mail goes to the lost mail down in, well, either in Minneapolis or down in Atlanta. And what I read about the one in Atlanta, they get over 90 million pieces of lost mail every year. Well, how do you lose 90 million pieces of mail? That's a lot of mail. It's all these notices and stuff that we're supposed to be getting that are going to the wrong address, not getting picked up and sent to the lost mail. And I think the address they're using is the lot. We're going to find out they have addresses different on two different forms, and we need to marry it together. Okay, certificate of the clerk that a suit, etc., has been dismissed. Certificate of the clerk in any suit, bill, or proceeding that has been pending, or a judgment decree, or a record suit, or a bill proceeding has been dismissed, or otherwise, okay, shall have been pending. So there's the certificates of the clerk that a suit is either pending, or it's been dismissed, or whatever. They have these certificates. Now, just real quick, in Rose foreclosure, those that are familiar with lis pendences in a foreclosure have probably seen the notice of foreclosure. May have seen. This is a notice that there's a foreclosure, right? In parentheses, lis pendens. But this isn't the lis pendens. What they should have filled out is something like this. Clerk's certificate of pending suit for lis pendens against registered land. Now this is in Ohio. No suit can become notice to or in any way affect the owner of or persons interested in or persons dealing with registered lands until a certificate of the pendency thereof is filed with the recorder and by him entered as a memorial on the registered certificate of title covering such lands. It is not necessary to file a certificate of such pendency in cases where attachment has been levied and a certificate therefore duly filed with the recorder. Got to be a certificate filed with the recorder. This is the clerk's certificate. So I, whoever this clerk of, whatever the court is, whatever county, certify that on some day a case number was filed and is now pending in the court wherein some plaintiff and some defendant, in which the plaintiff seeks something against the said something. Against the said what? They're not going to put your name here. They're going to put your estate here against your property. They're going to put a lien against your property. And with more fully enlarged appear the pleadings proceedings in said case. The full name, county of residence, post office address of each of the plaintiffs. The post office address. So you put the person's name, their county of residence, and the post office address. They didn't ask for your mailing address. It said the post office address. So Robert Allen Mertlewski, county of Kent, Rockford, Michigan. That's where my post office is located. Rockford, Michigan. 49341. Maybe. Under my hand and seal of the court. Okay. This certificate is filed with the clerk of some court in the county. So if somebody in Ohio can go find a clerk's certificate of pending suit for Liz pendants against registered lands, watch what happens. This is a lawful document because the clerk is going to be countersigned by the deputy who's going to put the seal of the court on it. Descriptions of lands affected. The lands which are to be affected by the filing of the within certificate in the office of the recorder of whatever county, as situated in the county of whatever, in the state of Ohio, and described in the registered certificates of title as follows: the certificate number, who it's issued to, the date, the registration book, the page. By the plaintiff. The plaintiff has to sign this, or actually the plaintiff signs, and then by his attorney. Got to have both of them on there. Are described, so, and these would be, the certificate number would be the registered certificate of title, and this would tell you that it's recorded in the office of the recorder. Now this is the great thing. Watch this. Look this sucker over. On here, it's got the document number, the court, the county, clerk certificate of pending suit, the number, who it's against, and what the amount is. This is going to be one of those $10 cases, right? You go pay whatever this amount is on this right here, and the foreclosure is over. You just paid the Liz pendants. It's the suit pending. It's actually where they're taking your property. The other one is all for show, to enforce this because you didn't take care of this, and now they want damages on it. And they're doing this through the clerk's office, and I think the court they're taking it to is the commissioners, because it used to be the commissioner's court, and the clerk, county clerk, was the clerk of the commissioner's court. Alright, so this is very, very, very important. If anybody who deals with a foreclosure that may have a Liz pendants involved, and if you can go take a look, yeah. Go back and do it again. And so I think that this is going to be, we always go and look for our court case when we go to the court to find our court case. Bobby was told to go to the Superior Court in Arizona. They may have some information on liens and such, and that's because we're looking for these certificates that are filed in the court. And this is a certificate, clerk certificate of pending suit for Liz pendants against. Now, Bobby said in Arizona, the Liz pendances are filed by the county attorney. I mean, I call them the state's attorney or the county attorney. I can't remember what it was said in there. But they're the ones who file them. which kind of makes sense because, if you had a complaint, you would go to an attorney, put in a complaint. They would look at it. If it was valid, they would open a court case. Right? That's your county attorney working for you. Except right now he's working against you. So this is what a notice of lis pendens looks like, and this is what a certificate of pending suit for lis pendens against registered land looks like. And this is in Ohio. Let's a couple of those out. Okay. What else we got here? Whenever any person interested in registered land or any estate of interest therein or charge upon the same shall be entitled to have any certificate of title, memorial, or other entry upon register canceled, removed, modified, and the register or personnel whose duty it shall be to cancel, remove, or modify the same do not act towards the same shall, upon request, fail or refuse to do so, or is absent from the county and cannot be found, or for any reason such request cannot be made upon him, a court of chancery may, upon petition by the person interested, make orders as may be according to equity in the premises, and upon a certified copy of such order being filed with the registrar's office, the registrar shall make such cancellation, memorial, or modification as shall be decreed in such order. You take it to the court of chancery, and they earlier showed how to do that. In the circuit court for the county of Cook, sitting in chancery. To the judges of the circuit court in the county for the county of Cook, sitting in chancery, puts it into the chancery court. And it says to file it. And so it's either with this attorney, you would go file your complaint, or you would file it with the clerk. And if you're having a problem with that, mail it to the judge. Any person feeling himself aggrieved by the action of the registrar or by his refusal to act in any matter pertaining to the first registration of land or any estate or interest therein after the registration or transfer or change of title or change upon same, filing or neglect, refusal, and making the registrar and other persons whose interests may be affected party defendants, and the court may proceed therein as in other cases in equity to make such order as decree as shall be according to equity and premises purported in this act. Okay, nothing contained in either two preceding sections shall be so construed as to remove the bar of any orders or decree or extend the time of limitation herein before provided, nor to affect the right of any bona fide purchaser or encumbrancer without notice filed with the registrar and noted as in the case of other memorials. Court, in addition to costs, may award damages, including attorney's fees. Indices. The registrar shall keep tract indices, T-R-A-C-T, tract indices, in which shall be entered the lands registered in numerical order of the township, ranges, sections, and in case of subdivisions, the blocks and lots therein, and the names of owners with reference to the volume and folium of the register in which lands are registered. But it should start with the township, then the range, then the section, each one getting smaller, a smaller defined territory of land, into a subdivision, then into a block, and then into a lot. That's how the indices should be. And when you look at the way they put these in some of these papers, they put range and then township, or section and township, not township, range, section. It says it shall be, the tract indices shall be township, range, section, then in subdivision, then block, then lot. And that would take you down to the volume and folium of the register in which the lands are registered to show you where the registered title is. He shall also keep alphabetical indices, in which shall be entered in alphabetical order the names of all registered owners and all other persons interested in or holding charges upon registered land in reference to volume and folium of the register in which the land is registered. So I think, again, if you give them the grantor's information and your warranty deed, they're going to find him in the alphabetical index. It's only because you haven't gone there yet to do the transfer that you're not listed there as the owner. But you are listed as the owner in the uppercase register of deeds because somebody went and registered your deed there without your permission. You didn't register the deed in the register of deeds. Your closing agent did. And did he have power of attorney to do that? The county treasurer, when Roe was talking to him about this today, says, well, you need to go and sue your closing attorney. Because he said, well, you registered your land, or you recorded your land in the register of deeds. And Roe said, I didn't record it there. It's the closing attorney did. And the guy didn't hesitate. He said, well, you need to go sue your closing attorney because he did it without your, if he did it without your authority. They put it into the wrong jurisdiction is all they did. They took it to the wrong register of deeds. We want it to go to the county clerk as the recorder of deeds. And what else these people do? So the county clerk, the office of county clerk dates to 1818 when it was titled the clerk of the county commissioner's court. The commissioner's court, right? That's what it was called. And their original job was to keep the records of the commissioner's court, and to receive the official bonds of county officials. And in 1848, it gave the clerk's duties ex officio recorders. In 1870, it removed the duties ex officio recorder from the county clerk in counties with a population of 60,000 or more. Yet in this county here, it says they're still ex officio the recorder. And I think the reason it says this is in the counties they're talking about, none of us are living. We're not seen in those counties. We're seen in the uppercase county. There is less than 60,000 living in every county. In the de jure counties, so that's why they're still ex officio the recorder. Clerk served as clerk of the county courts from 1848 to 1963, and were charged keeping court records, using all court papers, and keeping the court docket. Well, this said the county courts, which I'm going to say is not the same as the commissioner's court. It may be a county commissioner's court, but it didn't say county commissioner's court. They got rid of just the county court. They were doing this since 1818. And this one they only did start in 1848, so they're two different courts. They're still the clerk. And what they're the clerk of is the commissioner's court. And that's where this other court is taking place, where they're putting the Liz pendants and stuff in, I think, is in this commissioner's court. But they have us going into another court to defend the fact that we didn't go to this court and take care of it, so they went to another court to get us to take care of it. Whatever their craziness is. Keeps county assessment and tax list and filed use of assessors and collectors. So they got the county assessment and they got the tax list. Keeps records of all land tax forfeiture sales. Takes the payment for land redemptions to correct the state's assessment list. Yep. All those things are what the county recorder does, or the county clerk. They are made responsible for overseeing the county collectors and are also required to compute each taxpayer's school tax. Don't pay your school tax. They'll put a lien on you. In 1853, the clerks became responsible for calculating the taxes of each taxpayer and settling accounts with township collectors and making necessary corrections to the assessment books. Basically, they became the trustee of all other taxing districts. It's all done through one office. Keeping indexes of forfeited lands and lands sold for taxes. Member of the County Assessment Board of Review. their supervisor local and county elections. The recorder of deeds is the official maker of abstract of titles. And repealed certain sections of the code that required recorder to make and certify abstract of title to real estate, certain parts of it. Okay, so that's what the county clerk does as the recorder of deeds, abstractor of titles, register of titles, all under one hat. Now, who is this masked man? It's like most things, it doesn't appear to be the way it is. And so these are just the county clerk and recorder sections of the Illinois revised compiled statutes. County clerk as recorder. There you go. The county clerk as recorder. This is the recorder section. County clerk as recorder. And a bunch of stuff here. Where was the interesting stuff? You sometimes take too long. Okay, so this is under powers and duties of deputy recorders, duly appointed, qualified to perform any and all duties of the recorder in the name of the recorder. In the name of the recorder. So it's still going to have the recorder's name on it. They're just going to be doing the duties. And acts of such deputy shall be held to be acts of the recorder. And in case of the death of the recorder or his deposition from office, the chief deputy shall thereupon become the acting recorder until such vacancy is filled according to the election code. He shall file like bond vested the powers, yada yada, provided that if the recorder is called into active military service for the United States, his office shall not be deemed to be vacant during the time he is in active military service of the United States, but during the time he is in such active military service of the United States, the deputy recorder shall be the recorder. Well, guess what? There's a war flag flying in front of all these buildings, and so the recorder is on active duty. And since he's on active duty, they put a deputy in his place, signing under the name of the recorder. Office remain open during banking holidays. 3 distinct series of documents. You got some that are preceded with a B for bills of sale of personal property, chattel mortgages, releases. You got those that preceded by the letter C, a series of numbers. Certificates of discharge of members of the military, aviation, naval forces, and the other series of document numbers shall be used for all other instruments received for recordation. So C is going to be for certificates of discharge, B is going to be for bills of sale, and if it doesn't have one, it's for everything else. Mortgage or liens filed but not recorded. Upon receipt of a mortgage, trust deed, conveyance of personal property having the effect of a mortgage or lien on such property upon which is endorsed the words, this instrument to be filed but not recorded, or words of similar import. Right, so it's filed but not recorded. File for record is the same as not recorded. Just file for record. Or words of similar import by signed by the mortgagee, his agent or attorney, the recorder shall mark the instrument filed, endorse the time of the receipt thereof, and file the same in his office. File for record. It's not been recorded, just filed. This is interesting. Certificates of discharge or release of active duty. Certificate of discharge or member 4 copy of certificate of release or discharge from active duty of honorably discharged or separated members of the military, aviation, naval forces of the United States shall be recorded by each recorder free of charge in separate book, which shall be kept for that purpose. Or you'd say, okay, that's just everybody in the military. But then you go on to read that a military discharge form DD-214 is not subject to public inspection. It's not going to be publicly recorded. I think everybody's in the militia. In Illinois, you're part of the frickin' you're on active duty. Either a certificate of release or discharge from active duty. You have to file one or the other. Or it shows that you're still in the military. You're part of the militia. Go figure. Tell me it's not military. Quarters, office hours. Quarters is a military term. Barracks is one, quarters are. Right? When they say quarters and they're talking about the office at the courthouse is as quarters, I say that's a military officer. From 8 to 5 on each working day except Saturday. What does that mean? Does that mean they're open on Sunday? Boy, if they were open on Sunday but not Saturday, it would mean that the office is run by the Pharisees, because that's their holy day, Saturday. I don't know. I haven't been down there on the weekend. Somebody needs to go down and rattle the doors, see if you can get in on Saturday or Sunday. Except Saturday. Each working day except Saturday. Didn't say anything about Sunday. I don't know if they consider it a working day or not. The recorder shall collect a $10 rental housing support program surcharge for the recordation of any real estate related document. Wow, they're going to charge you $10 to record something. The payment of rental housing support surcharge shall be evidenced by receipt and shall be marked upon, otherwise affixed to the real estate related document by the recorder. How many people have one of those in Illinois? A receipt saying they paid the $10 rental housing support. Regardless of any other provision in this section, a maximum fee that may be collected from a Department of Revenue for filing or indexing a lien, certificate of lien, release, or subordination, or any other type of notice or documentation affecting or concerning a lien is $5. Imagine that. If it's does with a lien, it's $5. Made it pretty easy for people to put a lien against you. The maximum fee that may be collected by the Department of Revenue for indexing each additional name in excess of one is $1. Monthly list of conveyances immediately following each calendar month. Recorder in counties less than $1 million shall, upon request, transmit copies of all documents, plats, deeds covering conveying real property to the county clerk, the county treasurer, the tax map department, the supervisor and assessor of township assessors. So this is where they take your information and give it to everybody. In counties of first class, second class, no recorder shall record any conveyance of real estate unless the conveyance contains the name and address of the grantee for tax billing purposes. What is the address? Robert Allen Vertlewski, single man. Is single man my address? Recording and registering instruments transferring title to real estate or beneficial interest in real estate subject to a land trust. I think it's all in a land trust. If any home rule municipality has levied real estate transfer tax for which revenue stamps are required to be purchased under the Real Estate Transfer Tax Act, approved 1967 as amended, without proof of payment of municipal real estate transfer tax. You got to have a frickin' transfer tax stamp on your paperwork. How many people got that? It didn't happen unless you pay the transfer tax. Right? If any home rule municipality has levied a real estate transfer tax and a certified copy of ordinance resolution levying the tax specifying the rates and design and denomination that stamps evidencing payment thereof has been on file with the county recorder for at least 30 days, you had better pay the tax. Identification of persons preparing an instrument affecting title of real estate. No recorder shall record any instrument affecting title of real estate unless the names and address of the person who prepared and drafted such instrument is printed, right? Name and address has to be on there. Receipt. On the receipt of any instrument, writing the recorder or for recording or filing in the recorder's office. Two different things, recording or filing in the recorder's office. The recorder shall, when requested, give to the person leaving the same to be recorded or filed a receipt. Certificate of time of filing. The certificate, when signed by the recorder, or to which he has affixed his facsimile signature, shall be evidence of the facts therein stated. Okay. Fact is, they put it in. And these are the different kinds of indexes you're supposed to have. An entry book in which he or she may immediately on receipt of any instrument be recorded or filed, entered in number of its reception, the names of the parties, date, time, hour, receiving the same, and a brief description of the premise endorsed upon the instrument, a number